Thank you. And I guess we should mention that just in like the past, 7 years, the Benefit Corp and the L3C have become like the hot social enterprise models. They're both very new, and yet they serve a similar end, and yet the way in which they function is very different. Can you contrast them a bit?
Yes, a bit. The L3C was originally conceived as a capital formation tool. It has evolved and is being used for lots of different purposes, and we can chat about that if Amy lets us or if you ask a question about it. Whereas the Benefit Corporation is really intended to be a governance vehicle where the shareholder primacy rule that Amy described is trumped by a statute that encourages accountability to all of the company's stakeholders, not only its shareholders. So whereas one is intended really to attract capital, the other is really intended to mitigate risk for boards of directors.
I'm really happy that you raised that issue because that is a beautiful segue to our next question. So
happy to do that.
Yeah, well done, well done.
Thank you.
So Marc's one area of expertise is the L3C, and I wanted to focus some of our questions on that. The L3C is inherently low profit, right? It's the low profit limited liability company. Whereas other models that we've discussed and other ones that we haven't discussed, they have to make profit their primary pursuit. Can you discuss that a bit?
Right. I did not name the low profit limited liability company, and following Jared Boucher's excellent remarks on marketing and branding, had I been given the choice, I would not have named it the low profit limited liability company. The legal issue is not that the L3C must constrain profits. Quite to the contrary, I think my firm probably represents more L3Cs, more social enterprises than any other law firm in the country. And I can tell you that many of them are making significant profits. Many, for example, are knowledge-based businesses where we are defining their intellectual property in a very expansive fashion, cultivating it and then leveraging it through replication, through strategic alliance, through social enterprise franchising throughout the country and globally. And these are ventures that will not only maximize social impact, but have very significant revenue and very significant appreciation of assets. The low profit moniker comes from the fact that when assessing the investment in the first place, the venture should be sufficiently speculative or forecast sufficiently low revenues as not to attract private sector funding in the first instance. And therefore, the case is justified to tap into tax-subsidized investments from the foundation community. Were that not to be the case, if the venture could stand on its own and attract private equity, for example, from the get-go, as a matter of public policy, foundation money should not be utilized for that purpose. So it has to do with the way in which the assumptions and the financial forecasts at the beginning of the life of the social enterprise, before its concept may have been proven out, for example, or before capacity will have been built. That's the time at which one assesses whether this is low profit for that limited purpose. Thereafter, should the venture make significant profits, and the other test being appreciation of assets, should the assets grow significantly, there is nothing disqualifying about the L3C or the program-related investment that funds it, whether retrospectively or prospectively.
So you set me up for my next question. Once again,
Did it again.
This guy is just incredible. One of the most unique developments in social enterprise funding is, of course, program-related investments, which you mentioned, or PRIs. Normally, as a 501c3, a private foundation can only give funds to other 501c3s or nonprofit organizations. The PRI offers an exception to this. So could you expound a little bit more on what you were talking about and explain what the PRI is and how they allow foundations to invest in things like the L3C.
I'll be happy to. Ordinarily, the managers of foundations are obliged to manage their assets prudently, conservatively. They must diversify their investments. They must secure market rate returns. Their investments may need to be collateralized, all of which requires the trustees of the foundation to be good stewards of the resources entrusted to them. And in fact, if they make investments outside that pattern, both the foundation and its management may be subject to an excise tax for jeopardizing the mission of the foundation. The exception to that rule is the program-related investment, where foundation managers are permitted to make speculative investments. And not only can they make speculative investments, but those investments can count against the 5% distribution requirement that otherwise would be satisfied through grants. And they do so without peril of an excise tax. And the reason for that is they must qualify their investment as a program-related investment in that it is being pursued for charitable or educational purposes. So this is where the proof of concept, the social innovation, can be funded. But it also can be attached to program areas, and a program-related investment can be made in a nonprofit or a for-profit. If it's made in a nonprofit, it's going to be only debt, because nonprofits have no equity to sell. If it's made to a for-profit, like an L3C, it can secure equity position in the L3C. So if you look at the opportunity as one that involves a layered or tranched capital structure, if the foundation does the heavy lifting by investing in equity, now all of a sudden this brand new venture has a bank account, has cash in the account, and has net worth. It also has a social venture capitalist standing by in the form of that foundation, and it has the gravitas that attaches to that relationship, all of which may make it easier for the foundation now to serve as a catalyst where its funds are leveraged to secure private investments that otherwise might not be attracted to the investment at all because they may not be as concerned about the social mission of the venture. The other element is the program-related investments does not attract market rate returns. It attracts something significantly less than market rate returns. So if this is to be debt, the debt may bear a 0 or 1% coupon. If it's equity, it's going to be a disproportionately low equity stake vis-a-vis its investment. All of which now sets the stage for the forbearance of the foundation now to subsidize returns to other investors, allowing them to receive market rate returns from a venture that may only have modest financial returns in its own right, but the prospect of significant social impact.
Well done.
Thank you.
So just to take things one step farther, there have been some constraints on how these program-related investments are done. And your book went to press in 2011, right?
It did, yes.
And in the book, you mentioned how in 2010, the American Bar Association approached the IRS and proposed 17 additional PRIs.
Yeah.
What's the current status of that?
Now let me take you a step back. Program-related investments came into the law in 1969. So we have over a 40-year history of program-related investments. In 1972, the Treasury Department promulgated a list of examples, with a capital E, this is a term of art, intended to set forth fact patterns upon which attorneys and their social enterprise clients and nonprofit clients could rely in determining whether a given purported investment as a PRI in fact qualifies. Between 1972 and now, this year, no additional examples were forthcoming. So attorneys had to operate by analogy. There were some private letter rulings, there have been some cases, but those examples have never been expanded. So the section of taxation of the American Bar Association said, hey guys, time for you to supplement your list, given the fact the world has changed. And there are lots of different things where charitable dollars need to be funded, and they need to be funded through investments. So let's act, and here are some suggested new examples. And all of the suggestions, interestingly, were modeled off of private letter regulation, private letter rulings, or cases that had already been adjudicated. So every one of them was cited. It wasn't as if this was new legal thinking. This was merely to codify that which had already been brought into the law through other means. Well, earlier this year, in April, the Internal Revenue Service did issue proposed regulations, including a number of new examples. For example, community arts organizations that have weekly or monthly exhibits can be funded through PRIs, and lots of other things. Foreign investments, if deemed charitable in the U.S., are ipso facto suitable PRIs if performed outside the U.S., recognizing the importance of funding nutrition and health and other issues in education in the developing world. Well, two interesting things about the proposed regs that came out in April. One is the examples included within the proposed regs became law upon the proposal. Typically, there's a comment period, there's an opportunity to object, and so on. No. Treasury said, right now, you can rely on these as law. That's unusual, and it shows a strong commitment to the PRI process. The second interesting thing about the April proposed regs is the Treasury specifically states that the motivation for these proposed regs is at the demand of the foundation community. Not the social enterprise community, not the nonprofit community, but the foundations were beckoning for greater guidance, greater flexibility in making program-related investments. And if I could take a minute, I could even explain why.
Oh, please do.
Is that permitted? Okay. Let me talk a little accounting, not much because it's early in the morning. But understand that the foundations have two choices. They can either satisfy their 5% distribution requirement through grants, and this is what accounts for the feverish competition for grants among charities. Some would say to the distraction of away from mission and other things they ought to be spending their time and resources on. Or they can make program-related investments to the tune of 5% of assets, or some combination of the two. Now let's look at the accounting treatment of each. A grant is an expense. The foundation does its due diligence, writes a check, keeps its fingers crossed, hopes for the best, but the money is gone for all time. On the other hand, a PRI is an investment. Whether it's debt or equity or some hybrid security, that investment continues as an asset on the foundation's balance sheet to be recovered one day, it is hoped, with earnings, it is hoped. When that occurs, should it occur, that money now can be recycled over and over again in perpetuity. So you have a financial multiplier effect in a PRI that you don't have in grants, and consequently you have a social multiplier effect in a PRI that you don't have in a grant. And it's this very logic, for example, that persuaded the Gates Foundation about 2 years ago to establish a $100 million pilot project of PRIs. And it's the same logic that has appealed to MacArthur in my hometown, and Kellogg, and Kauffman, and Buffett, and many of the other larger foundations. But also, increasingly, we're now seeing mid-sized and smaller, including low-hanging fruit here, the Family Foundation, are interested in joining this party because nobody wants to be a pioneer, but nobody wants to be left behind either. So when you see thought leadership, like Gates, for example, which is highly visible, that thought leadership liberates others to follow suit and do the same with their portfolios because they see the merit in the position as well.